formalities apply only to a contract for a mortgage. Unless those formalities are complied with, a party is not contractually obliged to execute a mortgage. But that does not affect the validity of a mortgage deed which is actually executed. The formalities of a deed are governed by S. 53 Law of Property Act 1925 and they are complied with in this case. The distinction was authoritatively emphasized by the Court of Appeal in Helde v. Strathmore Limited, 2011, UCAR Civilian 542. That's what was executed, so he is affirming to you once again the point that there is no second contract. 80. However, at the possession hearing the claim was advanced simply on the basis of more than 2 months' arrears. I have looked at the witness statement of Michelle Tuai in support. It makes no representations that Mr. Crawford consented to a change in mortgage terms. Indeed, as observed above, one of the agreed facts in this case is that both sides accept that there was no change in the mortgage. I can find no basis for saying that any statements of the nature identified by Mr. Crawford were made to the court. The judge has looked at the witness statement of Michelle Tuai but not the accounts. It is hearsay and cannot be relied on. He then goes on to say that the witness statement makes no representations that Mr. Crawford consented to a change in mortgage terms. So the judge accepts Mr. Crawford's version and indeed has already made a decision to that effect. 82. This is dealt with by what has gone before. As I have already observed, a key mutually agreed fact in this case is that the Crawfords' mortgage did not change. Sadly, it would have been so much better for them if it had. The judge affirms in very clear language that the mortgage did not change. It would have been so much better for them if it had better for the bank, that is, arrears capitalization. 83. Mr. Crawford disputes the accuracy of the arrears figure claimed and also points to the capitalization of arrears undertaken by Bradford and Bigley. Mr. Crawford submits that if arrears have indeed been capitalized, then I am bound by the Northern Irish case of Bank of Scotland v Macready, 2014, NI Master 11 to rule that Bradford and Bigley have made an unconscionably illegal claim against him. This would also constitute a clog on the equity of redemption. The judge says that the arrears have been capitalized, and capitalized arrears are not an arrear. This means that they are claiming the arrears as a capital. Therefore the bank cannot take a claim against you. The claim against you is illegal. They are claiming the arrears as capital. This is an equity issue. You haven't any arrears, and possession can only be taken on arrears. He made it clear that they acted illegally. 85. The case of Macready confirmed that when arrears are consolidated they cease to be arrears, and in doing so acknowledged the authority and correctness of the Court of Appeal in Zidder. See paragraph 32 onwards in Macready. In the case of Macready, the court refused to allow the bank to both capitalize arrears and rely upon the arrears so consolidated as being outstanding arrears for the purposes of possession proceedings. It was simply an application of the principle that arrears, once capitalized, cease to be arrears and cannot be relied upon as such in a possession claim. There was nothing novel about that. So he's saying that the possession proceedings are not valid because the arrears have been capitalized and you can only take possession on the arrears and not on the capital. It's a capital debt, there are no arrears. It's a bombshell what you have got here. He writes clearly, if it's a capital debt you can't issue possession proceedings. 89. What Bradford and Bigley cannot do is rely upon previously capitalized arrears in this possession claim. They are not doing so. The last capitalization was in December 2006. These proceedings were brought on the basis of failure to make mortgage payments in 2012. So he's saying that when they now take proceedings, it's capitalized. The bank is asking for the full amount including the arrears. But if there are no arrears, the proceedings are not valid at all. And you paid all the arrears, and if there are no arrears then possession proceedings are not valid. That's what he writes. The proceedings were brought on the basis of failure to make mortgage payments. But you paid everything. There is no order for possession. There was one because you had arrears, but that was suspended. They gave you time to sort it out. So he confirms that if the facts are, as we know, that the arrears were paid, so the proceedings are illegal. 91. Here, Mr. Crawford has a point. I can find nothing on the statements of account which show when capitalizations have occurred, although the total mortgage debt figures are more readily understandable. From January 2010 the format of statements of account changed, but it is not easy to see at any given time what the live account arrears are. At the time of commencement of the possession proceedings arrears were said to total £1,802.90. That is not a figure which I could identify from the statements of account. When asked where it had come from, Miss Sardles for Bradford and Bigley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. The judge states that it is not easy to see at any given time what the live account arrears are. The reason for this is that the Crawfords paid the arrears. So Mr. Crawford has a point, but the judge did not establish the point. He couldn't establish it because he did not have the accounts. But Mr. Crawford has got the evidence that he paid it because he has the bank statements. Next, the judge says that he could not identify the figure of £1.892.90. This is for the simple reason that he did not have the accounts. All he has is the balance. Mr. Crawford paid it, that's the reason he can't identify it. Once again, the judge states. When asked where it had come from, Miss Sardles for Bradford and Bigley told me that it came from the computer. As computers should be our slaves and not our masters, such a response is not satisfactory. That's the reason she's not coming to court. This is a slap in the face from the judge. He's saying it clearly, is it not a bombshell? He says it is not satisfactory, and this is enough. You don't have to call it a lie. But he's not satisfied with her response that the computer is our slave, and not our master, but she is the master, eh? So he says, I'm not satisfied with your response. And this is a killer for the whole case. Because you can prove that he wouldn't be satisfied with many things that they say. And the point is that they say everything was fraud. It's a slap in the face, it's not satisfactory, the judge has decided it. There were no statements, the only statements were in affidavits or skeleton arguments. It's all hearsay and they didn't prove it. Therefore he said it's not satisfactory, so I don't believe your statements, or your statement is not valid and I can't take it into account. So take away all your skeletons, all your statements of truth and affidavits, and throw them in the bin. So now do you understand why she's not coming to court? Her skeleton arguments are dead. I want you to understand how beautiful it is. Excuse me, until I showed you this, how do you explain it, then? She said, it was stupid, that computers are our slave, not our master is her statement. Without proving it. He didn't want to say you've perjured yourself, you're a criminal and so on. You don't expect it in the civil court, it's enough that the judge says I dismiss your statement, or it's not satisfactory. In pure English, in normal language, you lied. Can you tell me another explanation? Or am I completely out of order talking rubbish? 92. However, none of this helps Mr. Crawford in relation to possession. The entitlement to possession is triggered by arrears amounting to 2 monthly installments, and no one suggests that such qualifying arrears did not exist both at the time the claim was issued and on the date of the order. Of course, because there is no order. It's a suspended order giving you the opportunity to pay the mortgage arrears, which gave you 6 months and you did it. So there was never an order. A suspended order is not an order. And at the end of it, when you stopped paying, everything was paid as of today. 93. That does not mean that Mr. Crawford is not entitled to challenge the totality of the debt. He can still do so when an account is taken of how monies are to be paid following sale of the property. Thank you very much. He hasn't got any knowledge of what the debt is. He has not had produced to him accurate accounts. But Mr. Crawford is entitled to establish it. This is the next step. He says this will follow after the sale. No, sir, it doesn't follow after the sale. It follows before you go to the sale. You have to prove that there was any debt. So, now this case is dead. To go and sell they need an order from the court for a sale. So they can't use the charge, because they are trespassing, in my opinion. Did he make it clear or not? Conclusion. 96. The Crawfords are fighting for their home of 25 years. Their desperation is easy to understand, and their predicament has attracted interest in the press and much public support. When the case came before me in February 2015, I was troubled that at the end of the mortgage term the Crawfords owed more than they had originally borrowed. So why didn't he establish it? Why didn't he establish that there was a debt? So he didn't finish the job. There were no accounts, so he didn't finish the job. So anything he had done before, which was in your favor, on an assumption, but you can convert that assumption to fact. But you don't have to confirm it. They have to prove that the debt exists. So he has opened you the door now, for the future, that you have got a case. And he's stated here, according to this, that they have to prove the debt. He has certainly opened the door for you for the next after this hearing, after this judgment, so your door is open. 97. Factually the position is now clearer. The reason that the Crawfords owed more at the end of the mortgage than they did at the beginning is that there is no longer an endowment policy which was supposed to repay the capital borrowed. However that came about, the Crawfords have known since at least 1999 that there was no means in place of repaying the original capital. Mr. Crawford was offered the means to repay capital by way of a repayment mortgage but refused. That explains how we have ended up at the end of the mortgage term without repayment of capital. 99. The order under appeal is a mortgage possession order. As I have indicated in paragraph 50 above, once there are qualifying arrears, 2 months installments, Bradford and Bigley is entitled to possession. There was no dispute that there were qualifying arrears. The order under appeal is a suspended order. This is misleading. The suspended order under the appeal is a mortgage possession order. There is no such order, but the proceedings are on mortgage. The judge then states that there was no dispute that there were qualifying arrears. This is an assumption by him. If it's true, and you have the evidence, and you know that you did pay, and he also knew about it, so there was no arrears. So they couldn't make a possession order. To clarify, Bradford and Bigley took the Crawfords to court in 2012 to obtain a possession order against them. There had been arrears in previous years, but these had been capitalized and so could not be used as grounds for possession. In 2012 the Crawfords were 2 months in arrears and the B&B took them to court over the 2 months arrears. The court decided to give the Crawfords the opportunity to pay the arrears, and they did pay them. So it was finished, and the proceeding on arrears doesn't exist anymore. And on capital you can't ask for possession, only on arrears. And in any event, if there had been arrears in 2012, then in 2014, when they want to evict you, if there were arrears they were capitalized, because they say the mortgage arrears. The B&B keep pushing the argument that because the Crawfords have not paid off the capital at the end of the mortgage, that arrears have once more built